Can arbitration clauses withstand court challenges? Imagine signing a contract that says any dispute will be settled through arbitration instead of court. You might wonder, can courts really enforce that? Let's find out. Arbitration clauses are common in sports and entertainment contracts. They say disputes go to private arbitration instead of a judge or jury. Courts generally support these clauses because arbitration is faster and keeps disputes out of public view. The Federal Arbitration Act, passed in 1978, makes arbitration agreements very hard to ignore. Courts tend to uphold them unless there is a good reason not to. But not all arbitration clauses are automatically safe from court challenges. Courts look at how fair the clause is. They check if both sides agreed to it freely and if the rules are reasonable. If one side had no real say or the clause is unfairly one-sided, courts can refuse to enforce it. For example, if a clause gives the league or company total control over the process, it might be seen as unconscionable and invalid. Clarity is also important. The clause must clearly say what disputes are covered. If it's vague or confusing, courts might decide to let the case go to court instead. Courts also consider whether the claims are legal or statutory. Many claims in sports and entertainment involve laws like employment rights or consumer protections. Courts usually allow arbitration of these claims unless the law specifically forbids it. Another concern is who acts as the arbitrator. If the clause names a league commissioner or a company executive as the decision-maker, courts worry about bias. They usually wait until arbitration ends before ruling on whether the arbitrator was fair. Recent legal cases have looked at how arbitration is handled when many people or consumers are involved. Courts have found some mass arbitration procedures unfair if they limit rights or put too much burden on the weaker party. In sports, arbitration clauses often appear in league rules or contracts with players and talent. Sometimes courts find these clauses unenforceable if they give too much power to league officials or if they are not fair. For example, if a player is forced into arbitration with no say, courts might say that's unfair. In entertainment, companies include arbitration clauses in ticketing or streaming agreements. Courts are paying more attention to these and sometimes strike them down if they restrict consumers' rights or prevent class actions. Overall, arbitration clauses can stand up to court challenges if they are fair, clear, and neutral. Courts are increasingly willing to strike down clauses that are one-sided or unfair, especially in industries where power imbalances are common. So, when drafting or signing these clauses, fairness and transparency are key to making sure they hold up in court.